Okay, so here we are. We're going to get started. So welcome everybody. It's so nice to have you in class today. Today we're going to dive in deeply to the Bill of Rights. We're going to look at every single one of the amendments in the Bill of Rights, but then we're going to also look at the history, where these ideas come from, this writ of rights, where's the foundation that the United States took these ideas from, how we've used them over time, and how they've changed from national and state balance with the Reconstruction amendments. And then at the very end, we're going to look at a modern hypothetical around the Bill of Rights during times of COVID. So to do that, we're going to be joined by Jeff Rosen. And Jeff, your camera is not on, just a warning to you.
Oh, well, let me turn it on.
I mean, you can just say Jeffrey Rosen. If you, there you go.
Oh, there you go. Absolutely. Hi, Kerry.
Hi, Jeff. It's so nice to see you. More numbers are coming your way in our emails back and forth, but we're so excited about class today. And I did let everybody know that at the end of class today, in about 30 minutes, we will hold about 5 minutes for office hours if anybody has election questions. We recognize that what a big week this is.
Absolutely. And we can talk about your big constitutional questions about the election. They are being debated by the courts as we speak. And if you'd like a great introduction to the novel constitutional issues that have to do with the counting of absentee ballots or mail-in ballots, we just did a great We the People podcast, which I think we can post in the chat, where both of our scholars present the arguments on both sides about whether or not late arriving ballots should be counted. So hope you enjoy that, and we can talk a little more about that after we talk about the Bill of Rights.
Yes, Bill of Rights. Let's start with our foundation. So Jeff, we have so many questions that came in during registration about the Bill of Rights, and some of the kind of the goals for the class that we're going to go over is, where does the Bill of Rights ideas come from? Why did the framers believe that it was necessary? How did the anti-federalists really make sure that this happened? And then how has the Bill of Rights changed over time? So that's some of the big questions that they have around the Bill of Rights. And when you're ready, we can walk through every single amendment and kind of roll from there and make sure everybody knows every single one of those 10 amendments. And then we'll dive into how we got them.
That sounds great. And I think you know what I want to do, which is screen share.
Okay, so I'm going to stop sharing. And I was like, I have slides, but I know he wants this is perfect for the interactive Constitution, if you ask me.
Well, it's because the most exciting feature about the interactive Constitution's exploration of the Bill of Rights is the ability to look at early drafts of the Bill of Rights from the Revolutionary era state constitutions. And friends, if you take nothing else away from this discussion, and I hope there'll be a lot of things because there's so many exciting things to say about the Bill of Rights, it's that when James Madison drafted the Bill of Rights in Philadelphia, he was not drafting it from thin air. He was cutting and pasting from Revolutionary era state constitutions that he had at his side. And those Bills of Rights are all on the interactive Constitution. So broadly, let's go back to first principles. The original Constitution did not have a Bill of Rights. Why not? James Madison and other Federalists initially said that a Bill of Rights would be unnecessary or dangerous. Unnecessary because the Constitution itself was a Bill of Rights. They said since Congress was granted only limited powers, for example, to coin money or to regulate interstate commerce, Congress couldn't presume to abridge the freedom of speech because it was granted no power to do so. And the second reason that Madison opposed a Bill of Rights is he said it would be dangerous. Our rights are so sprawling, so capacious. We have so many of them, said Madison. They come from God or nature, not from government, that to write them down would be to create a necessarily limited list. And some people might wrongly assume if the right isn't written down, it's not protected. So those are the two reasons. One, a Bill of Rights is unnecessary because the Constitution itself constrains Congress and is a Bill of Rights. And second, it might be dangerous because you might assume that the list was comprehensive, whereas in fact, our rights are too extensive to be written down. But in the face of oppositions from the so-called anti-federalists who feared really strong government power, Madison changed his mind. It's an amazing example of a statesman in the face of political opposition, but also on reflection, reversing himself on an important position. And he came not only to champion a Bill of Rights, but to draft it. And now we can go to the interactive Constitution and see how he drafted it. So we're going to start exploring. And here are all of the amendments. And remember, the first 10 amendments to the Constitution are known as the Bill of Rights. It wasn't until the 1940s that they started being referred to that way. Although the Revolutionary era state constitutions often referred to declarations of rights, the first 10 amendments were not known as a Bill of Rights when they were passed at the time. And we'll just read them because they're right here. Freedom of religion, speech, press, and assembly in the First Amendment. The Second Amendment, the right to bear arms. The Third Amendment, prohibition against quartering of soldiers. The Fourth Amendment, prohibition on unreasonable searches and seizures. The Fifth Amendment, which has a whole bunch of criminal procedure rights, including the right to grand jury indictment, the prohibition against double jeopardy, the right against self-incrimination, the right not to be deprived of liberty without due process of law, and the right not to have your property taken without just compensation. Wow, you know what? There's so much already. I could keep reading, but rather than just continuing to read from the Bill of Rights, we introduced 5 of them. Let me show you what I mean when I say that Madison was cutting and pasting. So if we go to the First Amendment Free Exercise Clause, I want you to spend some time, because I know you'll find it exciting, with this tool called the drafting table. The drafting table shows early drafts of all the main amendments. And we are right now on the First Amendment's Free Exercise Clause. Let's always begin with the Virginia Declaration of Rights. It was written by George Mason, and Madison had it by his side when he wrote the Bill of Rights, and Jefferson had the Virginia Declaration at his side when he wrote the Declaration of Independence. So this is the Virginia Declaration's first draft of the religion protections of the Constitution. That religion or the duty which we owe to our Creator and the manner of discharging it can be directed only by reason and conviction, not by force or violence. And therefore, all men are equally entitled to the free exercise of religion according to the dictates of conscience. That's such an important idea, friends, that our beliefs are the product of external evidence operating on our reasoning minds. And I can't alienate to Kerry the ability to control my thoughts and opinions because I can't entirely control them myself. They're the product of my reason. So that's why the rights of conscience are unalienable. And we see that here in this draft of Virginia, which talks about the free and equal rights of conscience. Madison used that language about conscience in his first draft, where he talked about the civil rights of none shall be abridged on account of religious belief, nor shall the full and equal rights of conscience be in any manner or any pretext infringed. Then we go through the debates and we see Madison continuing to talk about the Congress shall make no law touching religion or the rights of conscience. That conscience language is persisting as we're moving through the House. The House Amendment 3, Congress shall make no law establishing religion or prohibiting the free exercise thereof, nor shall the rights of conscience be infringed. Already as late as August 24th, 1789, this is when the Bill of Rights is being debated, that language about conscience is still in there, still going, and it's not until September 3rd that the conscience language drops out, and we have this language about no law establishing religion or prohibiting the free exercise thereof. So that is just so interesting to see those early drafts, and there are many more provisions that could help us understand what the rights of conscience are, including the New Hampshire Declaration, which explicitly names conscience as a natural right and says among the natural rights, some are in their very nature unalienable because no equivalent can be given for them. Of this kind are the rights of conscience. What's an equivalent? When I move from the state of nature to form a government in civil society, I surrender to the government temporary control over certain of my alienable natural rights. Alienable means I can alienate or surrender them in exchange for an equivalent. I got to get something back for the bargain. And the equivalent is usually greater security and safety of the rights I've retained. It's the reason I allow the government temporarily to control, to punish murder, is because I'm more secure as a result. And that's why the government has a monopoly on the punishment of private violence. But some things I can't alienate because I can't get anything back for it. And in particular, the rights of conscience, my power to reason, is the quintessential idea. All right, there's a lot of, I know there was a lot in there, but just look at how much we can learn just from looking at these great tools. And I'm going to pause for a breath and ask Kerry what she thinks.
I have so many questions, and so does Karen. So let's go for some. One of our students asked this earlier in class, and I thought it was a really good question. It seems like a lot of good ideas during this time period come out of Virginia. Is there a reason Do we just favor the ideas that come out of Virginia, or is there more weight of ideas coming out of Virginia? And if so, why? So that's the first question. And then we'll keep going, and two more, and then we'll jump to the next part.
It's a great question. The Virginia Declaration of Rights was extremely influential, well, largely because Madison and Jefferson were from Virginia, and they had it right by their sides when they wrote the Bill of Rights and the Declaration of Independence. And they knew George Mason, who became an anti-federalist. But because he was one of the leading opponents of the Constitution without a Bill of Rights, they needed to rely on his language in order to mollify and get Virginia's votes, because it was so important. And because it was it was a model for other states too, because it was pretty early. Remember, that was 1776, but some of the other ones are in 77, and Massachusetts is as late as 1780, as is New Hampshire 1783. But Virginia is not always the most influential provision. When we come, for example, to the Fourth Amendment, prohibition against unreasonable searches and seizures, let's look at Virginia, that general warrants are grievous and oppressive and not to be granted. Doesn't look a lot like the final Fourth Amendment language. It's the Massachusetts Constitution of 1783 that was the model here. Every subject has a right to be secure from all unreasonable searches and seizures of his persons, his houses, his papers, and all his possessions. So the Massachusetts model there is more influential. Massachusetts was where the writs of assistance were denounced in the 1760s. It just proved to be have a more robust search and seizure jurisprudence, and that's why it's more influential. So that's the basic answer. Virginia is always a good place to start when we're talking about the Bill of Rights, but it's not the place to end. There's one other thing that we've got to show, because Virginia is so influential here: the unadopted amendments. These are the ones that Madison proposed but didn't get through the House, and they include this provision, which was taken straight from Virginia, that powers delegated by the Constitution are appropriated to the departments. So the legislative can't exercise executive powers, nor executive, legislative, or judicial, nor judicial, executive, or legislative. It's a separation of powers amendment. We talked about separation of powers last week, and that comes from Virginia. Then there's the provision, there are two more I want to show you. That all power is originally vested in and derived from the people, that government is instituted and ought to be exercised for the benefit of the people, which consists of, it sounds a lot like the Declaration of Independence, but it's actually almost word for word from the Virginia Declaration of Rights. And it shows how influential that preamble was for Madison and Jefferson. The final proposal that was proposed but not adopted, Madison thought was the most important in the bunch. And it would have prohibited states as well as the federal government from violating the equal rights of conscience, there's that language again, or the freedom of the press, oral trial by jury in criminal cases. That didn't pass. And as a result, the original Bill of Rights, this is a big point, applies only to Congress. It says Congress shall make no law regarding the freedom of speech or the press. It doesn't say the states. It took the 14th Amendment, passed after the Civil War, to apply the Bill of Rights against the states and to achieve Madison's goal of forbidding the states as well as the Congress from violating basic rights, including the rights of conscience, press, and trial by jury.
So that's a perfect lead up to the Reconstruction time period. But Karen has a great question I want to make sure we sneak in here. So did Madison see that conscience was equal to morality? Did he equate those two together?
That is such an important question, Karen. And the best place to answer it is in Madison's remonstrance against religious assessments. Let me try to answer that as best I can, because it's a really important question. Madison believed that it's through our exercise of conscience that we make moral decisions, and also that we decide what we believe about the ultimate nature of divinity, whether there's a God or not. Madison has this really important distinction between reason and passion. If you go back to Federalist 55, remember he says in all large assemblies of any number composed, passion never fails to wrest the scepter from reason. He's getting that from this distinction, which is very common in the Scottish Enlightenment natural rights theorists, about a moral sense. And they disagreed about how this moral sense operates, but Francis Hutcheson thought we have certain instincts about what's moral and what isn't, and we use our reason and our moral sense, including our conscience, to restrain our unreasonable passions. Just before we started teaching, I was reading a new, for me, it's a few years old, biography of Benjamin Rush, the great founder who championed public schools in the new republic and also came up with the idea that our diseases of the mind may be physical as well as mental. And Rush distinguishes between our conscience and our he talks about reason and conscience separately, and reason is like the conscience and our moral sense. Our moral sense is our instinct about what's right or wrong. Our conscience is our decision in particular cases about whether to choose vice or virtue, as they put it. So that's a long way of saying that, in a sense, yes, conscience was a way of articulating the moral sense, but it the basic goal, and this is the really overwhelming point that you get throughout the founding period, it's self-control, self-mastery. All the framers thought that we had these unreasonable passions like anger, jealousy, fear, and we have to use our conscience and our reason and our moral sense to achieve mastery over those passions so that we can achieve the virtues of temperance, humility, prudence. Those are the classical virtues. In George Mason's draft of the Virginia Declaration of Rights, I'm not going to Google it, but you can find it. He actually says, because we all have to pursue happiness, therefore temperance, humility, prudence, and all these moral virtues our minds have to be free to pursue. So the way that we achieve happiness is by practicing virtue. The way we achieve virtue is by cultivating these habits of good temper, basically, of being a good person, of serving others, of being benevolent, thoughtful, charitable, not angry, jealous, afraid. And we use that through the exercise of our conscience. And that's why, just to tie this all together, you can tell I'm really interested in this question because I think it's so important. Just as the point of the separation of powers at the constitutional level is to control the people's representatives so that they can be governed by reason rather than passion, so the point of our exercising our moral sense and conscience at the individual level is self-control, so we can be governed by reason rather than passion. Self-control allows us to achieve private happiness. Self-control of the government through checks and balances and separation of powers allows us to achieve public happiness. And in that way, reason can prevail over passion. I hope that's the beginning of an answer to your question, and I hope to be able to answer it even better after I finish this Benjamin Rush book, but it's completely fascinating, and you'll see a lot of that language in these drafts on the Interactive Constitution.
I'm excited. If anybody ever gets to come to Philadelphia, you can go and look at Benjamin Rush's original garden at the Mutter Museum. Oh. It's awesome. It's the original plants because he was a brilliant doctor as well. So really impressive person of Philadelphia. You can come visit, and also just a great read. Now, talking about people that I adore and want to learn more about, what's the influence of the Reconstruction time period on the Bill of Rights, and how does let's bring up John Bingham and the 14th Amendment. How does that really kind of shift the power of the Bill of Rights to apply to the people and less just applying to holding back the national government?
All right, let's go check out the 14th Amendment. Is the screen sharing still work? Can you see the interactive?
Works great.
Great, okay. So now we're going to go to the 14th Amendment. That's not part of the Bill of Rights because it was passed, as you said, after the Civil War. And the provision of the Bill of Rights that incorporates the Bill of Rights against the states, according to the Supreme Court, is the Due Process Clause, although the framers intended it to be the Privileges or Immunities Clause. Now, this is such a technical, important, complicated question that my instinct is not to do anything more than just show you the drafting table so you can check it out on your own. And we'll talk a lot about it when we talk about the 14th Amendment. But if we look at privileges or immunities, we can see early drafts. And the original draft was Congress can secure to all persons in every state full protections in the enjoyment of life, liberty, and property. So there Congress is empowered to allow people in the states to enjoy life, liberty, and property, and also the same immunities and equal political rights and privileges. So that the early draft even included voting rights, amazingly. But the idea was that states were abridging a lot of those rights, including denying free African Americans or abolitionists the rights of free speech, denying African Americans the right to make and enforce contracts. So all of those rights had to be secured against state as well as federal infringement. And that's what the 14th Amendment ultimately did with the Privileges or Immunities Clause. And when the Supreme Court struck that down in the infamous slaughterhouse cases, it took about 100 years for the US Supreme Court to incorporate or apply the Bill of Rights against the states through the Due Process Clause.
Awesome. Okay, so as we kind of go through this Reconstruction time period and we look how it moves, so it's slaughterhouse cases. When do you really see what most people today, the modern person, thinks about the Bill of Rights? When do you start to see those court cases start to come out and kind of start applying people's rights, saying the state can't infringe on my freedom of speech or freedom of assembly and all those pieces, freedom of religion as well?
The very first case applying the Bill of Rights against the states is the Gitlow case. It's in the 1920s. It applies the First Amendment against the states. But most of the Bill of Rights was not incorporated against the states until the 1960s. That was the period when most of the provisions of the original Bill of Rights were applied against the states in a process called selective incorporation. It basically meant case by case, the court would ask, is this one of the fundamental rights that's essential to a free government or not? And if they decided yes, then it was in, and if not, then it was out. This process of selective incorporation was championed by justices like Felix Frankfurter and John Marshall Harlan. Justice Hugo Black, the great textualist, didn't like this. He said everything should be in, basically, maybe with a couple of exceptions like the 10th Amendment, which protects states' rights and can't be incorporated against the states, or the 9th Amendment, which says if a right isn't written down, don't assume it's not protected. But he basically thought the first 8 amendments just should incorporate as a whole. Now, he was kind of scorned at the time by Felix Frankfurter, but he's come to be vindicated. And since his time, the US Supreme Court has incorporated nearly all of the rights that it had left out in the 1960s, including just last term, the double jeopardy provisions were incorporated against the states from the Bill of Rights, and the grand jury provisions were recently incorporated against the states. So there's very little that has not been incorporated that remains. I think the Third Amendment has not been, but this Supreme Court is very sympathetic to incorporating the Bill of Rights against the states, just as Bingham and Black hoped.
And Third Amendment, just in case you forgot it, because I get why, quartering of soldiers without your approval in your home. Just wanted to make sure everybody knew that one. So here's a hypothetical. So I always, Jeff, I always like to wrap up with a modern hypothetical. And I really like this one from kind of our brief that we wrote around it. So during times of COVID, there has been either lockdowns or regulations on people gathering. So one of the questions that came up was, if they ban a gathering of over 50 people, does that violate the First Amendment protection for freedom of assembly? So if a group of people wanted to have a vigil or wanted to go outside and protest or assemble in some way, how do you balance the time of a pandemic with the time of people's right to free assembly? They could even be going to church, all of those questions. So that was the hypothetical. So we can send it to our audience and see how they answer, but we really wanted to dig in and say, how do we balance this in this unusual time?
Great question. Again, I'll give a shout out to we've done a bunch of podcasts on COVID and the Constitution. Check them out on We the People. And also, why not look on the wonderful interactive Constitution on the, just to show you where it is, the media library page collects all of these great podcasts and programs all in one place. And here are the recent ones, including just last week was US v. Google, the president and immigration election in the US in the courts. That was the one I told you was such a good exploration for the current election law issues, and you'll find the Constitution covered. Short answer, the Supreme Court said in the Jacobson case, in an opinion by Justice Holmes, at the turn of the last century, that public health emergencies allow mandatory vaccinations. A Jehovah's Witness who didn't want to take a vaccination could be forced to be vaccinated because of the public health risks posed to others by failure to vaccinate. So therefore, states have very broad power under what's known as the police power to prohibit assemblies and enforce quarantines for limited times. Now, there have been a bunch of cases by churches, for example, that say that they are entitled to a religious exemption to allow their congregants to meet. They should be exempt from the bans on groups of more than 50 people. The courts have divided a bit on this, but generally they've held that as long as churches are held to the same COVID restrictions as other public accommodations, they are not entitled to special exemptions, although some courts have come out the other way. The question of federal lockdowns or quarantines hasn't come up this time, obviously, because we haven't had one. Although if Vice President Biden wins, he's proposed a mask mandate, so that might be an interesting constitutional question. But broadly, Congress too has broad power in times of smallpox epidemics, and there was a big one, the yellow fever epidemic in 1798, and a lot of smallpox at the end of the 19th century, as well as the 1918 flu. So broadly, Congress has pretty wide authority as well. That's a very rough and ready answer, but more details in that great COVID and the Constitution podcast.
And I linked them in the chat as well. So one more final question before we wrap up this class is, and I'm pretty sure Benjamin Rush was a big part of that 1798 yellow fever epidemic, but the students did want to ask, which Benjamin Rush book are you reading?
I've just found it, and I just started it, but I can tell that it's good. It's by Stephen Field, and it is called, I got it right here on Kindle, which I love so much. Except I can't read the cover because the print is too small, but it's by Fried, F-R-I-E-D, and it's Benjamin Rush. And we've got to find the title because here's the title page. Revolution, Madness, and the Visionary Doctor Who Became a Founding Father. It looks really great. But that just got me to, and then I just downloaded the complete works or the selected works of Benjamin Rush, the selected works. It's edited by a guy called Runes. I find, friends, that once you get excited by a thinker, reading the primary sources is really good. So I really wanted to read his speeches, and he gave an amazing speech in Philadelphia to the Philosophical Society in 1796 about physical influences on the diseases of the mind, which seems so cool and exciting. So that was this morning's reading.
And so just to let everybody know, we started something last week and we hope you really like it, that at the end of the week, we follow it with an email with the reading list that you hear throughout the sessions, because everybody's like, I need that reading list. And we will send it to you. We try to pull it together. And it's a really fun way to keep the conversation going. And all of us, in times of COVID, at least we have more time to read. So that's a benefit. So Jeff, thank you so much. I want to wrap up the questions around the Bill of Rights. And we do have one question around election. So students, if you need to jump because the Bill of Rights class is over, that is totally fine. But if you want to stay for a couple election questions, we do have some in the Q&A. So Jeff, this was a question that came in from Joan earlier and has come up in the last class as well. What happens if there is a tie? And is there some type of end date that things will be solved by if there is conflict or a recounting of ballots or anything like that?
So if neither, let's go to the Constitution for that. If neither, although I don't need to, I can start answering a good question because this is quite an important one. If neither candidate gets a majority in the Electoral College, then it goes to the House of Representatives. And then the 12th Amendment gives the procedure for how you vote in the House. And in the House, which decides the presidency, each state has one vote. So since 26 delegations are controlled by Republicans at the moment in the House, even though the Democrats have an overall majority, then if the vote were taken today, then Republicans would have a majority in the House. However, I believe that if there's a tie in the Electoral College, it would be the new Congress, which will take place or take its seats on January 6th, that would decide the question of the presidency. And that's why Speaker Pelosi has said, hey, we've got to win more Democratic districts so that if it does go to the House, we Democrats will have a majority, Republicans disagree, and they want to keep their numbers. What's the date by which it has to be decided? The only date in the Constitution, January 20th. That's when the new president is inaugurated. But Congress, in the Electoral Count Act of 1897, which was passed after the disputed election of 1876, gave a bunch of deadlines for when states have to submit their electoral votes to make sure they're counted. And one big date is around mid-December. It was December 12th at the time of Bush v. Gore in 2000. I think it's around then. I don't know if it's exactly the same date in December. But any ballot submitted before then, a slate of electors will be presumptively counted. If states haven't, if they're dueling slates, that's the kind of nightmare scenario where you could have one slate of electors, say in Pennsylvania, say it was incredibly close in Pennsylvania. This is a hypothetical. And one slate certified by the Pennsylvania Supreme Court counts late arriving ballots, those arriving after Election Day, and they certify for Biden. And the other slate, certified by the Republican state legislature, says Trump is the winner. Both of those slates could conceivably be presented when the Congress is counting the electoral votes, which takes place at the end of December, I believe. And there's a very complicated procedure for how you count in the event of dueling slates. But the punchline of the Electoral Count Act is that in the event of a dispute, generally the slate certified by the state executive is counted. So the governor of Pennsylvania's slate would win under that scenario, and the Democratic governor might be more likely to certify the Biden slate than the Trump slate. Again, complete hypotheticals. We don't know. It would take an incredibly close election for all this to happen, but those are some of the possible scenarios.
I think that's really helpful. And a lot of those questions are around kind of what are those scenarios and possibilities. And this is going to be election week, people. So this is one thing that we're going to talk about all week long. We know this is going to take a little bit longer to figure out this year than in years past. But we are opening up a workshop for teachers or educators on November 4th at night at 7 p.m. We're going to be there. And if we want to talk about election questions, you feel free to join us. It's on our website. And then James did ask a question real quick. What happens if the president-elect dies before taking the oath of office on January 20th? And Jeff, I know didn't you just do a podcast on this too?
We did.
You're on it, man.
We had a podcast on on what happens if presidents die before. And I think it's technical enough that I'm going to ask you to listen to the podcast. It was so good. So rather than winging it, check out the podcast.
And I'll send you that link to the podcast as well, James, but great question. And we had lots of people reading the Interactive Constitution, which you all have in the chat. But Jeff, I want to thank you so much for hosting after hours class with us. I love this time for Q&A that are around the Constitution, but may not be on topic. And what a perfect week to kind of stretch some office hours in here as well.
Well, it was thrilling, and I'm learning a lot from the chats, including this interesting debate about Benjamin Rush. So excited that, Jacqueline, that it's your favorite founding father, and really interesting about the yellow fever epidemic as well. Thank you, friends. Keep reading, keep learning, and look forward to seeing you on Wednesday.
Great. Thank you so much. Bye-bye, everybody.